Picture this, a family farm on the brink of collapse in 1980s, buried under loans it cannot repay. The owners, husband and wife, go to bankruptcy court with a bold claim. We cannot repay you in cash, but we will repay you with our labor, our hard work, and our sweat. The bank says no. Labor is not collateral. The question travels all the way to the US Supreme Court. At stake is the foundation of capital structure. Can equity holders keep ownership in a bankrupt business by promising only future labor? The answer is in Norwest Bank versus Allers 1988, reaffirmed the absolute priority rule and defined the limits of new value exception. It is one of the clearest statements in US history of why debt trumps equity. To understand this case, let's pause for definitions. Chapter 11 reorganization allows a struggling business to restructure debts and continue operating rather than liquidating under Chapter 7. Capital structure, the hierarchy of debt and equity in a company. Creditors representing the debt sit above shareholders, the equity. Absolute priority rule. In bankruptcy, senior creditors must be paid in full before junior creditors or equity holders retain value. New value exception. An equity holder may keep an interest in the reorganized company if they contribute substantial new capital, money, property, or something tangible to compensate creditors. This doctrine was born in Case versus Los Angeles Lumber Products 1939. But the question remained, what counts as new value? Is hard work and expertise enough? That's the stage for Allers family. The Allers owned a farm in Minnesota. Like many family farms, during the farm crisis of 1980s, they were over-leveraged, owing large sums to Norwest Bank. Unable to make payments, they filed for reorganization under Chapter 11. Their plan, they would keep ownership of the farm. In return, they promised to dedicate their labor, experience, and expertise, essentially their sweat equity, to make the farm profitable again. From their perspective, this was fair. Without them, the farm had no value. Their effort was essential for generating future income. They weren't asking to walk away. They were promising to work harder. The bank saw things differently. Sweat equity is intangible. Creditors cannot liquidate or trade labor promises. Allowing this would gut absolute priority rule. Equity would always leapfrog debt by making vague promises. The legal question was stark. Does sweat equity qualify as new value under bankruptcy law? The Supreme Court unanimously sided with the bank. Justice Byron White delivered the opinion. Key points of the opinion are: absolute priority is strict. Creditors must be repaid in full before equity can retain ownership. No shortcuts. New value must be tangible. The court reaffirmed Los Angeles Lumber. New value means money or money's worth. Sweat equity is not new value. Labor is not capital. The court distinguished between financial contributions and future services. Services are uncertain, unenforceable, and lack immediate exchange value. Policy consistency. Allowing sweat equity would undermine the entire capital structure. Every bankrupt owner could claim they'll work harder to keep their businesses. Justice White famously wrote, "This reinforced a clean conceptual definition. Debt is contractual claim which is senior, legally enforceable. Equity is residual claimant, survives only if creditors are whole. New value, tangible, present contribution of money or assets, not sweat, not promises." The Allers family lost their farm, but the case gave business law clarity. For bankruptcy courts, equity holders cannot smuggle themselves into reorganizations by pledging labor. The only way equity survives is by writing a check. For creditors, the decision strengthens secured lending. Banks gained confidence that in bankruptcy, their claims would not be diluted by vague promises. For entrepreneurs and MBAs, the message is conceptual but practical. Capital structure is not just a chart in finance textbook. It is enforced by law. Debt is senior, equity is last. Only real capital can rescue equity in distress. In modern restructurings, from GM to Hertz, you see the logic of Allers everywhere. Creditors negotiate repayment terms. Equity gets wiped out unless it brings new value in the form of fresh cash. Sweat equity, expertise, and hope do not count. Broader legacy of Norwest Bank versus Allers sits alongside Los Angeles Lumber 1939 and 203 North LaSalle in 1999 as the trilogy of Supreme Court cases that shape corporate reorganizations. Los Angeles Lumber defined absolute priority rule. Ehlers clarified that sweat equity is not equal to new value. 203 North LaSalle limited insider new value deals without market testing. Together, these established the bedrock of capital structure law. Hierarchy of claims is absolute. Equity only survives with capital, not labor. Reorganizations must reflect economic reality, not sentimental equity claims. Think about it this way. If capital structure is a waterfall, debt is at the top, equity is at the bottom. When the waterfall runs dry, top still gets wet, the bottom doesn't. The Allers family tried to reverse gravity by offering their sweat equity instead of water. The court said no. In finance, labor has value, but in bankruptcy law, it is not new capital. So the next time you see a distressed company, whether a farm, an airline, or a retail chain, remember the rules were set not just in Wall Street boardrooms, but in a Minnesota farm case in 1988. And those rules say debt first, equity last, no exceptions for sweat.